So today we're going to talk about layoffs and immigration and some information that I hope will be helpful to you in the unfortunate event that, that this is something that you need to worry about. Just a typical disclaimer, just saying that, of course, I'm not your attorney. Don't rely on this. Immigration guidance can change. So you don't ever want to rely on something that you're seeing online as being specific advice to you. So just keep that in mind. Here's some contact info for our firm. Lots of different social media handles for both me, which is I'm US visa lawyer on a lot of things. And then our law firm is McEntee Law Group. So there's some contact info there for you, and our main firm email address and our phone number. Immigration policy is changing often. You'll see even today with some of the changes that I go over, some of the updates come from policy changes. So, guidance can come out that might be more helpful and that might clarify some of the law. So it is important that you keep yourself informed. You can connect with me on LinkedIn. I think that's probably the place that I share the most comprehensive updates about things. So I'm happy to, connect with anybody who wants to connect with me there. And just a couple of other things I'll point out is our firm. So we just handle immigration exclusively, but we do a couple of different online events on a regular basis. So that is the first Friday. So the first Friday of the month, an attorney from our firm will do a presentation about some updates, and you can submit questions ahead of time. And then we also do webinar Wednesdays. So periodically on a Wednesday, not any set Wednesday, but we'll announce it ahead of time, and you can, jump on and learn about a specific topic. And then we do record these, and they're available on our YouTube channel. So a little bit about me. I came to the US as an international student, and I'm now a naturalized US citizen. I've been practicing as an immigration attorney for over 16 years, and I've done a lot of work with international students and people on all sorts of visa types. So I have lived this experience myself, and a lot of our team have gone through the immigration process as well. So I think kind of knowing in a way how it feels to be in your shoes helps us give compassionate and empathetic advice to people. I've also written a book on startup immigration that might be relevant for some people. I'm happy to find a way to get a copy to you. It's an ebook as well, if that's something that you're interested in. Okay, so this is the meat of what we're going to be discussing today. We're essentially talking about what happens if you end up getting laid off, or if you fear that you may be subject to a layoff. We're kind of going to go through where do you even start thinking about this, and some updated guidance talking about the grace period. We'll spend quite a bit of time on that. H-1B portability, what that means and why that's beneficial, change of status, different options that might be available for you, compelling circumstances EAD, which is something that I will be talking about as well, green card options, porting or moving a green card when you're in the middle of the process. Is that something you can do, or what happens if you're in the middle of the green card process? And then if you decide to leave the US, things you need to keep in mind. I do have some slides at the end that kind of go over some of the requirements of, let's say, some of those change of status options. I don't know what we'll get time to cover, so I have left the slides in there. We can, go over them if we get a chance. So, and just a reminder that if you do want to ask a question, two things to keep in mind. Number one, this is a public forum, so just, be mindful of the question that you're asking. Everyone's going to see it. Secondly, please put it in the Q&A as opposed to the general chat, because it'll be easier for me to see it in the Q&A. Okay, so let's get started. So if you're in the US on a work visa and you've been laid off, or you're worried about getting laid off, I know that you're going to have a lot of questions. Sometimes employers who do kind of mass layoffs, or they do a series of layoffs, or just a batch of layoffs, they give their employees some kind of options, like a packet, and it might include some advice from their immigration attorney. So that might be an option for you. But it is unlikely that the attorney who is probably the attorney for the company will be able to directly assist you. They may be able to advise, but they may not be able to assist with filing a change of employer, so on and so forth. But it would be good to, if that's available, for you to get advice from them, just to see what options you may have as well. I do think it's important that you consider getting independent advice from an attorney that can advise you independent of the company. And if the attorney is the attorney for the company, you know, their hands may be tied to a certain extent. We advised a lot of people when those big tech layoffs happened during the course of the pandemic, and we advised people about their options independent of their company. But I think the goal of this presentation today was to give you some proactive advice. So, I mean, I hope nobody ever needs this advice, but if you do, at least you will have, you know, some knowledge ahead of time. So I hope it provides some comfort. So that's the plan, to give you some tips now, so that you can avoid complications down the line. You know, the great thing about the current administration is that they have been very proactive in terms of creating policy across the board. Some of you may have been in a presentation that I gave a couple of weeks ago where I spoke about lots of different policy updates from the Biden administration, everything from updates in relation to, you know, the new AI executive order to national interest waiver green cards. You know, here's another place that we saw some very helpful guidance. So during the, you know, a lot of the layoffs, there was a lot of confusion around immigration, and immigration is not very clear at the best of times. So, you know, it's an outdated laws, and the laws don't fully flesh out every type of scenario. So there's a lot of room for interpretation and a lot of gray areas, and that creates confusion. So what this administration did was they actually created some policy guidance on their website. And I've included here the link and the screenshot. So, you know, when you're looking at stuff online, you know, looking at the source of it is important. So this comes directly from the uscis.gov, which is the government's website. And you'll see here that this screenshot here is entitled Options for Non-Immigrant Workers Following Termination of Employment. Okay, and I just think this is important to just kind of think about the wording that they use here. They say, you know, when non-immigrant workers are laid off, they may not be aware of their options and may, in some instances, wrongly assume that they've no option but to leave the country within 60 days. So that's really helpful. They wanted to provide clarity and some options for people. And the website kind of went through some different options. So, I just thought that was really nice touch by the administration to give some clarity to people that were obviously feeling very confused and, you know, stressed out about layoff in the midst of everything. So this is some great guidance from the USCIS's website, and I'll share this so you can have the link there. So, you know, once we've seen the guidance, and we'll get into some of those options, but before we even get there, I think that I want to really bring up this idea of a grace period. Hopefully this is something that people have heard of. And, you know, I'll get into kind of how you determine what a grace period is, why it matters. But again, before we even do that, we need to be aware of our I-94. I'm hoping if this was in person, I would probably ask people to raise their hand to show me, you know, I would ask for, you know, raise your hand if you know what an I-94 is and where you can find your I-94. So your I-94 is, as a non-immigrant, so as somebody who's not on a green card or not a US citizen, so you're considered a non-immigrant. As a non-immigrant, your I-94 is probably one of the most important immigration documents that you should ever really be aware of. It is what controls your status in the US. It is separate to a visa stamp, separate to an EAD, or even, you know, other types of documentation surrounding your status. And it tells you what status you are in, and most importantly, how long you can remain in the US. Students are admitted for duration of status. So that's if you're on an F1, but I know some people here are on other visas. And if you're on a working visa, you're going to have an expiration date on your I-94. So everybody, after every trip, you should check your I-94 online after you return from every overseas trip. You, again, looking at this website, .gov, right? You're going to an official government website and you're checking your I-94 to make sure that you were admitted in the correct status and you were admitted for the correct amount of time. So this is relevant to your grace period because you need to know when your I-94 expires. So first thing to do is, again, you should do this independent of any layoff considerations. You should always be checking your I-94 so you know when your status expiration is. If you entered the US and your status has since been extended, so let's imagine you entered the US on a H-1B visa in January of this year. And let's imagine that your I-94 online, your original H-1B was supposed to expire in June. So your I-94 online would show a June expiration date. But if since then, if before that June date, your employer filed to extend your H-1B, you would have gotten an approval notice with a new I-94 attached to the bottom of it, assuming your status was extended here in the US. So there may be times when the I-94 online there may be times when there's a document that is actually more recent and controls your status versus that, that I-94 online. But either way, you need to know when your status expires. Most often it's controlled by it's either your I-94 online or the I-94 on the most recent approval notice. And if you are terminated when you're on, some of these common visas, including H-1Bs, Ls, Os, TNs, you may be eligible for a 60-day grace period following this. And this comes from a 2017 regulation. Before then, there was no grace period at all. So there's a 60-day grace period. So your 60 days, you may have this grace period of either 60 days or whatever's left on your I-94, whatever is shorter. It's important. So if your I-94 is set to expire before 60 days, then your grace period is not going to be 60 days. It's going to be whatever that shorter period, which could be 45 days or 30 days. Now, work is not authorized during your grace period, but you can file a transfer or a change of status, and we'll get into that. So, but just know that this concept of grace period is very, very important for certain people. Now, these questions come straight from USCIS guidance because there was a lot of confusion about this grace period. The kind of most important thing, I think, is like, if you have a grace period of 60 days, when does that grace period start? And how this is relevant to layoffs is like, does it start the day you stop working? Well, what if you're getting severance pay? Or what if, you're still getting paid, but you don't have to work, you're not actually performing services because you've been locked out of all your accounts? Like, when does your grace period start? Because you need to know when it starts, because you need to know when it ends, right? So the guidance from the USCIS said that the grace period starts the day after termination of employment. And here's what they say: typically determined based on the last day for which a salary or wages is paid. So, which, leads us to, seems to suggest that if you're getting paid, then, the last date that you kind of get paid, or the last date of a pay period, well, then your grace period would start after that. And that was really beneficial for people because they were getting severance pay. So anyway, this is direct guidance from the USCIS. People would want to get specific advice. If you were in a position where you were laid off, you really would want to get your own advice about when your grace period starts, what about severance? So, but just be aware of some of these Q&As from the USCIS. Another question was, how do you apply for a grace period? And we know, right, that it's not something you apply for. It's basically automatic. If you're in a situation where you're covered under the regulations, you should be able to be like in that 60-day grace period, up to 60 days, or the I-94. So you don't necessarily have to apply for it. And it applies if you voluntarily leave your job or if you're terminated. So it's not based on the circumstances surrounding the end of your employment. How many times can you use your grace period? Once during your authorized petition validity, and then they give some examples. Like if you're terminated from employer A, you may have 60 days following that. If you had a new employer period, a new employer file a petition, you may also get a second 60 days for that period. But it's once per petition approval. And then what's your status? So the USCIS considers you to be maintaining status during the 60-day grace period, which is important. Importantly, you cannot travel during the grace period. So if you leave during the grace period, you cannot come back in on your grace period. So just keep that in mind. And if your employment is terminated when you're outside the US, you don't get a grace period in the US. So, or if you're able to come back in, before the notice period ends, like before termination, then you may be able to get grace. But if you're outside the US and your termination is effective then you can't use that to come back in on. So it's really for people who are in the US during a termination or during like the effective date of a termination. This was an important clarification as well. If you have a dependent that's working on a EAD, so a spouse that's working on a work card, there were some questions about whether or not their work card would continue to be valid during the 60 days, and the USCIS confirmed that yes, if the spouse has an EAD, that's incident, that's so connected to your visa, that their authorization to work remains valid during the 60-day grace period. There's a question here about OPT, and they do say that the grace period is specific to these workers in E1, there's a whole list of them there, H1B, L, O, TN. It's not for F1 students. And during the F1 OPT period, there are limits to how many days of unemployment you are permitted. And that is kind of the grace period is just not relevant, does not apply to F1 students. So you need to be mindful in any scenario of your days of unemployment. And I know you work directly with the International Students Office in relation to that. Okay, so that's kind of the end of the grace period. There's a lot of info there, but the information is super helpful from the USCIS. So just know that if you're if you're terminated, there is 60 days. We'll talk about what you can do in those 60 days, but just note that when we talk about changing status or transferring your employer, that can happen during that 60-day grace period. Now, I know that there probably are some people on H1B visas here, and H1Bs are pretty sought after for lots of reasons. And one of them is that there's this thing known as H1B portability. And what that means is that, it's a benefit that is, I think, specific to people in H1B status. So the portability means that you can file a change of employer from one H1B employer. You can file a change of employer case to another. And portability allows you to work for the new employer when that transfer is received. Assuming it was non-frivolous and assuming it was filed timely, you can actually work on receipt, and you do not need it. The case does not need to be approved for you to start working. Now, some other statuses that you would be changing to don't necessarily, like an O1 or other types of options, don't have that same benefit. It's specific to this H1B portability. It allows you to work with a new employer on receipt of the transfer. So you can, let's imagine a scenario where you're on a H1B, you get terminated, you have your 60-day grace period. During that 60 days, you find a new employer. You can file a transfer to a new employer, assuming it's filed during that 60-day window. Now, note that a H1B case cannot be filed overnight. There are certain things that need to be certified by the Department of Labour in order for that case to be filed. So you'd need probably at least 3 weeks to get the case prepared. So while you do have 60 days, you know, you couldn't sign a job offer on day 58 and think everything's going to get filed in time. That wouldn't happen. And portability only applies if you're going straight from H1B in the grace period to another H1B. So for example, if you were on H1B and you couldn't find a new employer and you filed to change your status to a visitor, for example, and then you later found an employer and wanted to change back to H1B, in that scenario, that's not portability, because you would be in that intermediate, you know, you'd have a B change of status pending. So you would need to wait for that case to be approved in order to work for the new employer. So hopefully that makes sense. Another thing I wanted to bring up was the possibility of transferring your H1B to your own company. There are some myths surrounding H1Bs and owners of companies and startups, and sometimes people think that you can't have any ownership in the company. But over the years, you know, and all the time that I've been practicing, we have regularly filed H1Bs for people where they own some of the company. There is an employer-employee relationship requirement, so there needs to be some advice about how much of the company you should own. But recently there are some updated proposed regulations that will make it even easier for people who own even a majority of the company to sponsor their own H1B. So just wanted to put it on your radar. We have actually successfully worked on a H1B transfer for somebody who was terminated by one of the big tech companies. He had this great idea for a startup. We were able to work with him. He got the company set up and we filed the transfer to his own company within the 60-day grace period. So it is possible, but you definitely would need to be moving quickly to get there's a lot of moving parts that would need to be done in order for that to happen within the 60 days. But it is a potential option for people. So as I mentioned, you know, the 60-day grace period permits you to be in the US. You can also file a transfer of, example, H1B. And you can also file to change your status from whatever you're in right now to something else. And again, I wanted to, anytime you see like the quotes, the parentheses, that's taken directly from the USCIS. And I wanted to put this in bold because I thought it was important. But filing a timely change of status, so timely meaning within that 60-day grace period, can permit you to remain, assuming again the grace period or the I-94 expiration. So timely filing based on your own situation, it can allow you to remain in the US while the application is pending. Because obviously if you file a change of status, it's not necessarily going to get adjudicated like immediately, depending on what you're changing to. Some options cannot be premium processed. So chances are it's going to be pending for a bit. But if you timely file it, and if it's non-frivolous, that will actually stop your accrual of unlawful presence until the application is adjudicated, as long as you didn't work without authorization, either before it was filed, while it was pending, and you maintaining your status prior to the filing and the change of status. So that's good news. If you timely file it, you know, you can be in the US while it's pending. And if your change of status, so COS here, change of status is ultimately approved, then your status is changed and you've been in a period of authorized stay for the entire time. So kind of just like treats that as, you know, just a period of authorized stay, and then your change gets approved. If, however, it's denied, well, then you generally would accrue unlawful presence as of the date of the denial. So it's just so important that these cases are filed properly. We've had, like just earlier on today, somebody came to us that they had filed change of status on their own and they did not file it correctly and the case got denied. And, you know, it's just, I can't stress the importance of just getting advice that is really specific to your situation from somebody who is experienced and an attorney. You know, you just, in my opinion, immigration status is not something that you want to be taking risks with. So I just would encourage people to okay, so someone's asking, what does a non-frivolous application imply? I mean, it's like anything else, it's open to interpretation. But I would say if you're filing a change and there was like no underlying basis for it, so if you try to file a change for a new H-1B employer and there was no legitimate job offer or no, there needs to be merit to the underlying application. Which of course, as an attorney, we would never file a frivolous application. But yeah, I think that's open to interpretation, but there has to be merit to it. So what can you file a change of status to? Here's quite a few options that I've outlined here. We're not gonna, I'm conscious of the time, it being 5:25. I have fleshed out some of these further, but I'm just going to fly through the list here to see if any of these are important or any of these might sound as like an option that you might want to consider. So E2 visas, these are for people from treaty countries, and if you have money to invest into a new company or buy an existing company. Unfortunately, nationals of India or China are not on the E2 treaty list. But a lot of countries are. If this is something that might be suitable for you, you could potentially file a change of status to E2 during your grace period. An O1 visa if you have extraordinary ability, if we can prove that you're at the top of your field, things like that. Sometimes people get intimidated by the term extraordinary ability, but sometimes people are more extraordinary than they think. TN visa, again, some of these are employer sponsored. The O1, you can set up your own company potentially and have that act as your sponsor. Same with the E2, the TN, you're going to need a job offer with the US company and you need to be from Canada or Mexico. You could also potentially change to a dependent visa. So if your spouse, sometimes two spouses are on H1Bs, and then maybe if one was getting laid off, they could go on to H4 of the, of the other spouse, but we would need to see about work authorization. The L2 could be an option if both spouses were on independent working options. Change to F1 student visa, change to B visitor status. I'm going to flesh that out a bit more. And another thing that the USCIS said was they would consider expedite requests on a case-by-case basis. And they do have the discretion to approve an expedite request if one of the criteria for expediting has been met. So for example, if you were trying to get on a H4 and you needed like a H4 EAD, and we felt like we could make a compelling request for an expedite, that might be something that could happen. But just keep in mind that the processing times may impact some of these options for you. Okay, I've answered that one live. Someone's asking, is it permissible to work on a fellowship for a different company while on a H1B? Okay, I think that's a situation that you need legal advice for in relation to you, but H1Bs are really your H1B and your work authorization stems from your petitioner approval in the US. So generally you're working as the approved petition, and your employer is the petitioner on your H1B. Okay, so as mentioned, one of these options is to file a visitor visa application. So there was some guidance that I felt was particularly helpful here, because really sometimes people need to just buy some extra time. And this comes up in the context of the scenario, the example that I gave, where you're on a H1B, you can't find an employer, you can't get everything done within the 60 days, but you're pretty sure that you will be able to get a new employer. But maybe just not within the 60 days. Okay, so in that scenario, could you consider filing a change of status to B to just give yourself a bit of breathing room? And you potentially could, right? Now, I don't want to get into too much complexity here, but there was a situation before this guidance came out where if you had filed for a change of status to B, and that was pending, because it would be pending, the processing times are so long. If you later found an employer that wanted to sponsor you and you filed a change back to H1B, right? Sometimes the USCIS was saying they couldn't approve the change back to H1B if this B in the middle was still pending. And the processing times for B cases were so many months. So even if you timely filed it and you had a new employer and you were premium processing the H1B, they were saying that the bridging, the kind of B in the middle needed to be approved. So this was fantastic guidance. So basically says, if an employer, so if let's say employer B, the second employer, or I'll use a number because there's like the B visa and it might get confusing. So let's say the second employer, employer 2, files the H1B for you and files it with premium. They're saying now that the USCIS will generally process this pending 539, which is the B case, and the H1B petition at the same time. And so they're saying that there should be no delay in adjudicating the I-129 back to H1B because of the pending I-539, which is the B case. So this is basically the opposite of what was happening before, where they were holding these cases until the middle B had been approved. So that's really great news. They're saying that that they wouldn't do that and that they would adjudicate the pending B, which we had actually argued for and gotten them to do that, but sometimes they were pushing back on that. So this is great news, and it gives people a bit more comfort in, using this transferring to B option. Another thing is, what if you're in the green card process and you are filing for this B in between to buy yourself time? Like, is that possible? What if you don't necessarily want to leave the US, but you just want to buy time? So some of these questions were answered as well in a favorable way. So the government says here that having an approved or a pending I-140, which is an immigrant petition, so a green card petition, shouldn't have any impact, so long as you maintain an intent to depart down the line and you continue to maintain your residence. So they're saying having an approved I-140 alone is not necessarily going to impact your B. And they also say that searching for employment and interviewing for permission are permissible, which is fantastic, because people were concerned about, doing those types of things while in this like B period. So I think it just gives people some extra comfort. So, okay, I'm just going to close these questions that came in. So, okay. So overall, you can see how specific guidance is very beneficial. Again, assuming the guidance is favorable. We've also dealt with previous administrations that were issuing guidance that was not so favorable, but I think for this administration, very comprehensive and very favorable guidance in times of really crisis for a lot of immigrants. So we're very, very grateful to see proactive advice that was just very helpful. Okay, another thing that came out that I think was, you may have heard about this, compelling circumstances EAD. So most people will probably know the acronym EAD, which is an employment authorization document. Excuse me. So this guidance came out in June 2023, and it was very welcome as well. So I just, again, this is a screenshot from the USCIS website, and I'll get into what the guidance is specifically, but it's new or updated guidance in relation to what's known as a compelling circumstances EAD. So this option has existed for a while. It's just, it wasn't clear what would amount to compelling circumstances in the context of some of these layoffs. So the government has said that essentially this is a stopgap measure to allow people who are on the path to permanent residency and will helps them out by preventing them from having to leave the US abruptly. So the requirements for eligibility on this are, if you need to be the beneficiary of an employment of an I-140. So an I-140 approval, you can get an EAD for up to a year if there's no immigrant visa available for you on the visa bulletin, which changes on a monthly basis, but really impacts, right now can impact a lot of people in the EB2 category, but really has always impacted people from India and people from China. But so if you're in this situation and you face compelling circumstances, right? So it's like, what are compelling circumstances? Well, I'll show you on the next slide. But if you start working, if you apply for this and it gets approved and you start working on your compelling circumstances EAD, you're no longer maintaining your non-immigrant status because you're kind of working on this like hybrid EAD, but you're in a period of authorized stay, so you're not accruing unlawful presence, which is important as well, very important for your status. So what does compelling circumstances mean? So we were trying to argue before the guidance came out, like, this is like unprecedented. There's all these layoffs. People have been in the US for so long. A lot of people have gone to school and spent a lot of money here and have been like, you know, contributing to the economy and like all the things that we always say about the benefits of immigrants to the US. And then this guidance came out. So some of these things I think would have kind of always been considered compelling circumstances, you know, things like medical, you know, serious illnesses or things like that. But a lot of people wouldn't have necessarily been in that like serious medical illness. It was, they had compelling circumstances, but not necessarily medical circumstances like that. But this guidance shows us that substantial harm could include your priority date. So you've been in the US for so long, you still don't have your green card because you're from India or China. You know, your kids are in school or you're in school. Mortgage records, you know, this is like great specifics about what we can use to show compelling circumstances, long-term lease records. And it also just is common sense, right? There's landlords who have rented places to people for long term. And if they get laid off and then, you know, there's such a ripple effect of a layoff. And I just think the last thing that people need to worry about is their immigration status and having to uproot their kids. I have 2 kids of my own. You know, I can't imagine how stressful that would be. And so now we know that we can use some of these things in support of compelling circumstances. So priority dates, education records, mortgage records, leases, documentation, you know, surrounding your home country, significant disruption to your employer. Anyway, so these are other types of things that we can use, which I think is like very beneficial because, you know, if you couldn't get like a H-1B employer, but you wanted to work, but maybe, you know, you just needed to work somewhere else and not necessarily in a H-1B job, or, you know, for whatever reason, there wasn't a H-1B petitioner available. The compelling circumstances EAD is a work permit. So it would give you some more flexibility there. And I think that this has really opened up this as an option for people. So again, guidance can change, but this is the guidance that we received from the Biden administration, and it was extremely welcome news when we saw it. Okay, I'm going to talk about some green. I think I have a question. Can you apply for compelling circumstances EAD only if you get laid off? Well, I mean, I'm not sure what your compelling circumstances would necessarily be otherwise. If you had a job and were still working, then I don't know how you would be meeting. I'm just trying to see if there's anything specific to, I just don't know why you would, if you were still working for your H-1B employer. I'm not sure that this would really apply to you, but maybe there's something, I don't know, maybe I just need to talk to you separately to see if there was something else going on. So, okay, you're enrolled in school and your kids go to school. So is this in a situation where I think I might need to talk to you directly, but this is for people who, if you go back to the, you know, it's for people who are in the US, the main applicant is in the US in E3, H-1B, H-1B1L or O, and they are applying. So they have an approved I-140 and they're in that status. So if you're in an F1 status, then you're not, if I'm guessing that's what your situation is, then you're not necessarily coming in under this category. So there are some specific requirements for this. And maybe there's other types of compelling EADs, I know there are, but not necessarily this one. This is like specific for people who are in that type of working visa and get laid off. So okay, green card options. For some people, a green card is the end goal. For some people, it's not. And obviously everyone's preferences are different depending on you know, what your long-term goals are. But you know, if you have been laid off and you are considering staying longer term, or you're already kind of in that path, you know, there are some potential green card options. If you're in, you may be able to consider some family-based green card options. If you're in a serious relationship or you're married to a US citizen or green card holder, you know, there might be an option there available for you. US citizens and green card holders can sponsor spouses. So we could talk about what that would look like for you. Spouses of US citizens, there are more benefits in terms of if the actual petitioner is going to be a US citizen versus a green card holder. Just in terms of green card availability and other types of kind of allowances, forgiveness, let's say. There's more of those if the person you're married to is a US citizen versus a green card holder. But some other green card options would be potentially this national interest waiver green card, where you can self-petition. But there is going to be a backlog, most likely, unless you have a priority date from before or some other type of or unless things change. They change on a monthly basis as well. So we don't know that's, it's probably not always going to be the case, but at the moment there is. And EB1A, the Extraordinary Ability Green Card, it's the green card version of the O1, but a higher standard. You can also self-petition, but there's a backlog for some categories. Now, your ability to stay in the US based on a green card is based on the filing of the 485, which is like the final part of the green card. And it's not just on the first part, which is I-140 in an employment-based scenario or a self-petition, or I-130 in a family-based scenario. So, a green card might not be the saving option for people if you've been laid off and there's a backlog in your category and you just filed the I-140 petition. That is not going to permit you to remain in the US while that's pending. You need to be also able to file the 485. And you can't do that until there's a green card available in your category. So, okay. So just note that there potentially are some green card options for some people. Now, what if you're in the green card process with an employer and you get laid off? Like, how's that going to impact your case? This really does require an individual analysis, but I'm just going to give some general info here. So I'm probably not going to be able to answer specific questions here about, if this is your situation, just because it's very individualized. But one thing to note is that an employer is not required to withdraw an approved I-140 petition. Some things they have to withdraw, or they should withdraw, like a H-1B petition. There are wage obligations that are applicable or that still continue, even if you get laid off. So they do need to withdraw H-1B petitions, but not I-140 petitions. So you could, if you're in the situation, talk to your employer about whether or not they are going to withdraw the I-140. A lot of people don't. So, and there can be benefits to having an I-140 approval. You can use it for H-1B extensions beyond the 6-year limit, and you can recapture a priority date if you have a previous approved I-140, so keep your place in line. So there's other things there. You also, a green card process, depending on where you're at in the process, if you get terminated, if you get laid off, you may not be able to continue that process with another employer. And you can only really continue it with another employer if you're at, the final stage in the green card process and you have your I-485, that final piece on file for at least 180 days. You can potentially transfer to a new employer if it's in the same or a similar occupational classification. So we could assess the options and see whether or not, they fall within that same or similar. Also, I don't have this written here, but layoffs can impact an employer's ability to sponsor you or sponsor other people for a perm green card process, because part of the perm recruitment green card is recruiting and showing that there's no qualified US workers available. And if there's been a layoff in the area, they may be obliged to offer this position, your position to, if they were sponsoring you, to that laid off worker to see if they want to take it before proceeding with the green card sponsorship. So it can be just a bit difficult to get a green card sponsored in a recruitment green card if there have been some layoffs. So that is something to just be aware of as well. Layoffs impact green cards in a few different ways. And again, keep in mind that there are some green cards that you can self-petition for. So they're not necessarily dependent on an employer that are based on, you know, you self-petitioning. So if everything, you know, if you determine that you want to leave the US after a layoff, and some people do, some people decide that, you know, they're ready to leave the US. And if so, you know, there's some things to keep in mind. If you're at the end of your 60-day grace period and you have not filed anything to change employers or change your status, you know, you obviously should be leaving the US to avoid violating your status. If you end up accruing unlawful presence, you can subject yourself to a significant bar, which could be 3 years or 10 years, depending on how long you've overstayed. You do need to disclose any violations on future applications. So just be mindful of things like that. If you're laid off and you're on H1B or E3 or potentially O, depending on a few things, the employer might have an obligation to pay for reasonable return transportation for you. So that is something that you should talk about with the employer. You don't need to take it if you determine that you're not leaving the US. They need to offer it. They can't obviously force you to leave the US, but there is an obligation to offer to pay at least reasonable return transportation. And if it was a thing that you determined, you know, you couldn't get it, you didn't want to transfer your H1B, or you just were not in a position to do so, like if you were on an L, for example, and you can't transfer that, and you didn't feel like an O was ready for you right now, but you could always leave and maybe reapply for another visa later. And you could do that with either H1B or, you know, other types of options that might work. So the decision that you make now doesn't necessarily have to be one for the rest of your life. You can always reassess as circumstances and things change later down the line. So I mentioned that I probably wouldn't get time to go into real details here, but I just fleshed out some requirements for some of these specific options: the E2, the O1 visa, some policy updates, different green card options here, national interest waiver green cards. There's some great executive orders for people working in AI and different critical technology fields. So, you know, I think that, so here's our contact info. I hope that nobody ever has to contact us about a layoff, because obviously it's not something that anybody wants to have to discuss. But, you know, should this come up for you, I hope that you feel like you at least have some proactive information here ahead of time, that will be helpful for you. I have just like a quick 2 minutes left. I don't know if anybody has any last questions before I jump off. But I'm happy to be available to talk to anybody as, oh, you're very welcome. I'm so glad that you found it helpful. Like I said, it's a hard topic to even think about or to discuss, but my goal is always to really give important advice that helps empower people on their immigration journey. So I hope I was able to do that today. And I'll make sure that you can get a copy of the webinar as well. And yeah, like I said, I hope you never need to use any of this advice, but it's some proactive info for you in the unlikely event that you need to use it. Oh, you're so welcome. I'm really happy to get some good feedback from you. It means a lot, because I know that, you know, this is quite overwhelming, and I want to make sure that I'm giving the information in a way that is easy to understand. So I'll make sure that you get the webinar recording and that you can watch it back in your own time if you need to. And yeah, and we're going to send out a survey, I think Sandrine said. So if you're looking for additional webinars, if there's any one topic that you would want to hear, please feel free to ask it. Okay, so somebody's asking, I have one quick question that I will do. You're very welcome. Is the TN faster for a green card than a H1B? Okay, so the TN doesn't have green card intent, so it is a temporary intent. So you can potentially go from TN to green card, but you just need to be, there's some things you need to keep in mind. The H1B is a fully dual intent visa, and it allows you to pursue a green card at any time. So for that reason, it may be a better option. But, you know, I think we would need to guide you on some strategy there. And there's pros and cons to lots of immigration options. So people generally need some advice about what are the pros for them, what are the cons for them, and then ultimately, you know, help you figure out which one is going to work best for you. Okay, I'm right at 5:50. Thank you all for joining me this evening. I hope you stay warm. It's very cold this evening, and I will be back with another webinar very soon. So take care, everybody. Bye.